Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to this week's episode of Winning Isn't Easy. Before we get started, I've got to give you that legal disclaimer because the Florida Bar has said to me that I can't give you legal advice on this podcast. But now that I've said it, I assure you that nothing is ever going to prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, if you're on disability benefits or you're applying for your disability benefits, there's a lot you need to know. And one of the most important things you need to know is the games that disability carriers play with your Social Security, disability, or retirement benefits. I'm going to talk about three things today. One, what's in your wallet? It depends on what is in your disability policy or plan. Two, can a disability carrier like Aetna deduct Social Security retirement benefits from your ERISA long-term disability benefits? And three, does a disability carrier like Aetna have to explain why it rejected your favorable Social Security decision? Let's take a break for a moment before we get started. Welcome back to Winning Isn't Easy. Does a disability carrier like Aetna have to explain why it rejects a favorable Social Security decision when they deny or terminate your benefits? Many ERISA disability insurance policies or plans require that the disability policyholder or plan beneficiary apply for Social Security disability benefits when they apply for their ERISA disability benefits. The disability carrier obviously wants to reduce the amount of your benefits by the receipt of the Social Security disability benefits and even those of your minor dependents. Again, this depends on the terms of the policy of the plan. But I want you to understand that there's a United States Supreme Court decision in MetLife versus Glenn that clearly states that if a disability carrier denies or terminates your benefits, they have to confirm in the denial letter that they have considered the Social Security decision and explain why they rejected that Social Security decision in finding that you weren't disabled or terminating your benefits. But what happens if the ERISA policy or plan doesn't require or request that you apply for Social Security benefits? What are their obligations at that point to explain its position? Now, this is a twist, I will admit. And again, this is policy specific. I'm going to tell you about the case of Yoakum versus Aetna Life. And I think the court got it wrong. I'm not afraid to suggest to the court that they got it wrong. It wasn't my case, but nonetheless, I think it's instructive. Unum was a UPS employee who was disabled as a result of irritable bowel syndrome and Crohn's disease. Also, she had interstitial cystitis, pelvic floor dysfunction, and suffered from anxiety and depression. Clearly, she was disabled. Now, her long-term disability claim was denied by Aetna, and she ultimately filed a lawsuit in federal court in Kentucky. The court upheld the denial, and in doing so, addressed Yoakum's argument that the denial was arbitrary and capricious and should be overturned because the denial letter failed to explain why Aetna had disagreed with the Social Security award. It's well-settled law that the disability carrier plan isn't bound by a Social Security determination when reviewing a claim for benefits under ERISA. However, case law suggests that it is arbitrary and it's capricious not to explain why it's rejecting the Social Security award when the carrier or the plan requires or requests that the policyholder or plan beneficiary apply. What's different about this case, as I've said, is Aetna didn't require Yoakum to apply. So the court said that it wasn't reversible error when Aetna didn't explain why it rejected the favorable Social Security award. Now, I think the judge was wrong because under ERISA rules and regulations, a disability carrier or plan has to provide the policyholder or the plan beneficiary with a full and fair review and explain what it considered, what it didn't consider, why it considered what it did, and how it arrived at the decision to deny benefits or terminate benefits. Perhaps in this case, the court felt that Yoakum didn't help Aetna out because Yoakum never sent Aetna the favorable written decision. or the claims file. And many times the disability carrier will request a release asking for a copy of the Social Security file, which I have my client sign. So the court said that Aetna had no reason to explain why it didn't consider the decision. I read these cases because I think there are lots of lessons to be learned. And I think that regardless of whether the policy or plan requires or requests a disability policy holder or a plan beneficiary to apply for disability benefits, that you should be doing with your lawyer the following. 1, sending in the entire Social Security disability application and supporting documents. 2, as part of any Social Security disability claim, I regularly get residual functional capacity forms from the treating physicians, which are much more thorough than the attending physician statement forms that disability carriers have your doctors fill out. I want that residual disability capacity form to be part of the material that is sent to the disability carrier. There are also times when I will secure a vocational evaluation as part of the claim and submit it in the Social Security claim. I want that to be part of the claim. Now, if there has been a hearing, there will be the testimony of a vocational evaluator. So there are times when I'm actually also ordering and submitting the audio transcript of the hearing so that the disability carrier understands the hypotheticals that were asked of the vocational evaluator and how the judge, Social Security judge, got to the Social Security decision. If you've had a functional capacity evaluation, we want to submit that as part of any Social Security file if it's been filed with the court. And then, of course, you want a copy of the written Social Security decision. While the disability carrier can sort of cherry pick the stuff in the Social Security disability claim, I tell you, the courts will not be impressed if you're not supplying that information to the disability carrier and are reluctant to overturn a wrongful claim denial or termination on the basis that the carrier didn't consider what you didn't send them. Got it? You want to make them respond to the fact that your benefits were awarded. And if they don't do it properly, and they're required to do so by the terms of the policy or ERISA regulations, then you've got an avenue of attack. Got it? All right. I hope you've enjoyed this week's episode of Winning Isn't Easy. Please like this page, leave a review, share it with your friends and family, and subscribe to this podcast. That way you'll be notified every time a new episode drops. I hope you tune in to the next week for another insightful episode of Winning Isn't Easy. Thanks.